much for joining us this evening if you're in the US or this morning if you're dialing in from Australia. Before we get started, I would like to make a couple of announcements on behalf of the American Australian Association. For anyone that is going to be in Texas this week, I invite you to join my colleagues from the American Australian Association at Australia House at South by Southwest. We'll be there all this week and we would love for you to join us. If you are Australian, I would like to let you know that our scholarship program is open to candidates right now. Applications are due at the end of this month, so you've still got a couple of weeks to get an application together. And we are giving scholarships to veterans, graduate education scholarships, and grants in the arts. All the information is on our website, and I wish you the best of luck with your applications. So now I am delighted to welcome back Zjantelle, our favorite immigration lawyer. I always learn so much from these presentations, and tonight will be no exception. I'm really looking forward to all of your latest updates, and thank you to everyone, not just for registering, but for all the great questions that you've submitted. We'll be getting through a lot of those tonight as well. So Zjantelle, welcome. Let's get started.
Amazing. Hi, Louisa. It's so good to be back. I love doing these. We've done a few, so welcome to anyone who's on here for the first time, and welcome back to anyone that's come back. And for the first timers, we've done a lot of these over the last couple of years. And we've delved into topics previously. I'm going to share my screen here and get started in our usual format. So previous topics that we've covered furlough, we've covered Long Island E4s, we've covered RFEs for I-129s, green card holders outside the US. So that was one that we got still some questions for this time, Louisa, that we are seeing, some questions on. We're not covering it in depth this evening because that webinar from March 16th last year is still pretty relevant, so people can go to that. We had other webinars on premium processing, social media footprint, visa revalidation. So if anyone has any of these questions, they can refer back to those, which can be found on the AAA website, our website as well, as we record them and repost them. So tonight, what we're going to discuss the automatic work authorization for E3 spouses, E1 and E2 spouses, and L1 spouses, and just go through how that works. We'll also talk about the other visa categories and their spouses. Can they work yet? Can they not? What's the deal? There was an update from USCIS with respect to O1s that are in the motion picture and television field, so I'll touch on that. Australian entry requirements, because we are still getting a lot of questions from people with respect to their non-Australian spouses or children. What do they have to do to get into Australia? US entry requirements, an update on that. It's H1B period right now to register for the H1B lottery. So a timely topic right now is, should people register for the H1B lottery if they're on an E3, or even if they're not on an E3, if they're on an O1 or any other category? And so how I typically approach that when clients ask me that question, we've got, this is not necessarily timely, it's like relevant always, especially with St. Paddy's Day coming up and people drinking, and US visa consequences of alcohol-related offences. So what can happen if you need to apply for a visa and you've had a DUI before, or any kind of alcohol-related offence actually, or arrest. So we'll go over that as a reminder for people. E3 visa processing times and consulates. I know that's a hot topic people want to know about. And then just a lot of people asked about the green card timing for green cards, both employment-based, family-based, and timing for citizenship. Which there's some good news there because the timing has sped up compared to during the pandemic. Okay, before we start, I did want to touch on what's happening in the Ukraine, which is, every day I can't even read the newspaper, Louisa, it gets me so upset. So we do get a lot of questions of people saying, what is the situation in the US for people from the Ukraine? What can we do? What can Ukrainians do? So if a Ukrainian national was in the US before March 1st of this year, 2022, then those people are eligible to file for temporary protected status. which is a status that allows them to stay for 18 months and get work authorization and travel rights. But if the person wasn't here before March 1, 2022, the US government has not facilitated anything specific for Ukrainian nationals to be able to come to the US. So there's no refugee visa or asylum visa that's been specifically carved out for this situation, which is sad, but it is the case. So what are the options? Some of the options are that Ukrainians, there are the neighboring countries that are taking the Ukrainians in, such as Poland, Germany, Hungary, Israel, Belgium, Netherlands, Mexico as well, they can travel to. Once they're there, they can enter the US if they already have a visa. Unfortunately, Ukrainian nationals don't have the privilege of visa waiver, which is when people can come to the US without a tourist visa and just come for up to 90 days. Ukrainian nationals actually have to apply for a tourist visa. So in the Ukraine, you can't do that right now because the US consulate is closed. But they can, if they get to Poland, Germany, or any of these countries that accept them, they can try to get a B visa appointment at one of these countries to get a tourist visa and then try and enter the US. Or if they have another kind of visa, they can enter the US. And once they're here with the visa, they can apply to extend their tourist visa or change status in the US to another work visa if they would qualify for one. But there is nothing that, we get a lot of questions with, my cousin is in the Ukraine, my brother is in the Ukraine, can I sponsor him to come here? That is not an option right now. So they have to get in with either a tourist visa or other kind of work visa right now. And our hearts go out to those in the Ukraine and all our Ukrainian friends. Okay, so what we were going to talk about, and I just want to, in advance, I've had bronchitis and last week, so if I cough, I apologize in advance. I'm trying to swallow it right now. Okay, so we wanted to touch on this great news, which is amazing for Australians that are in E3D status and the spouses of E1s, E2s, and Ls. So typically, a big topic for us in our webinars, Louisa, has been the delay in the processing of EAD cards. So up until now, a spouse had to apply for a work authorization document when they came in on an E3D or an L2 as an L2 spouse or an E1 or E2 spouse. And those EAD documents were taking 8 months to come through. So we saw a couple of things happen. First, they instituted a rule last November that said we're going to allow people that are renewing their EADs to be automatically extend them, and I'll touch on that in a moment. But then as of, they did also announce that E spouses and L spouses will have work authorization incidental to status. And what that means is just by having the E3D visa in their passport or the L2 visa in their passport, when they enter the US, and now finally CBP, which is the airport, has caught up to know how to annotate these as of January 31st. So anyone coming into the US in E3D status or L2 status or the spouse of anyone E2, their I-94 will be annotated to show that they are a spouse rather than potentially a child dependent. So the I-94 will be, I've listed them there, should be annotated with E1S for an E1 spouse, E2S for an E2 spouse, E3S, that's the one that most of our viewers are probably going to be concentrating on, E3S or L2S. So if you've come in after January 31st, you should check your I-94. And if you look down here, this is what your electronic I-94 will look like. And sorry, for an E3, it will say this, E3S. If it does have E3S, then you can use your I-94 together with your passport and your marriage certificate to get a social security number. We did get some questions from some viewers before the webinar asking, do we not have, does the spouse not have to get a social security number anymore since it's incidental status? Still need to get a social security number because most employers, to be able to put someone on payroll, require a social security number. So I still encourage the spouse to get a social security number. If you already have a social security number, your social security number will stay the same. You don't have to go and get a new one. So they'll take their I-94 with their passport, their E3D visa, if it's an E3D, L2 visa, if it's L2, and this I-94. And that will be sufficient. These three documents will be sufficient, together with your social security number, for your employer to fill out the I-9 form. And I-9 forms have been updated to include this as acceptable for evidence of work authorization in the United States. This one here is for if you filed an I-539, which is either a change of status or an extension of stay for your E3 or L2 from within the US, you get an approval notice. So we've seen the approval notices that have come in after January 31st. So this one came in on February 1st for our office, annotated with the right E3S here, so that, because those approval notices come with a new I-94 at the bottom. So the new I-94 at the bottom of the approval notice will trump their electronic I-94, which most likely won't be updated. So they'll be able to use their approval notice with their new I-94 at the bottom to show to their employer together with their visa and passport. So this is great because so many E3D spouses have been waiting for their EAD that hasn't come through. So if you're one of those people that before January 31st, you filed for an EAD because you needed to, and you haven't received it yet, so you haven't been able to start working, a solution would be to leave the US right now, and you can go to Canada or Mexico to do this, and then come back in through CBP. And then the CBP officers are still not quite fluent in this and may not even know about it. In fact, all of our clients that have done this have had to really push the CBP officer and say, hi, I'm here, I'm in E3D status or L2, whatever this one of these it is. And I need my I-94 to be annotated with E3S, not E3D. And sometimes the immigration officer will say, well, I've never heard of this, and they'll have to get a supervisor, and then the supervisor will come back. Definitely push for it, because you can't get the incidental to status work authorization unless your I-94 is annotated with that. If you have entered after January 31st and it was not annotated with E3S and you just got E3D, and I'm just using the E3 because it's the more common right now, but every time I say E3D, just if you're an L2, assume that this applies to you too. So if it was not annotated this way, there is a way to contact deferred inspections at the port of entry you came through and request that they fix it. If you have any trouble with that, we can definitely assist with that. So just contact our office and we'll help. Anyone that entered before January 31st, CBP will not, and deferred inspections won't change it. So it has to be that you entered after January 31st of this year for that. Okay, so I'm just going to get a little cough in. For children, so a few people asked, can my children work? Still, dependent children on L's and E's still cannot work. And that was the reason why they created this differentiation between the spouses and the children. So children will be annotated with a Y, E1Y, E2Y, E3Y, L2Y, so that they will not be allowed to work. Okay. What about other spouses? So we have H4, which is the spouse of an H1B. We have O3s as spouses of O1s. F2 is the spouse of a student on an F1. J2, spouse of a J1. And P2, spouse of a P1 visa holder. So H4 spouses. So if you're in H1B, your spouse who is in H4 status, if they're on a dependent visa of yours, is not allowed to work until, if you are the H1B and you're going through the green card process and you have an approved I-140, which is quite far into the green card process, at that point is when the H4 spouse is able to apply for an EAD. But the H4 spouse still has to apply for an EAD. They do not get any incidental to status rights like the E3, L, and E2 and E1 spouses. The H4 spouse can take advantage of automatic extension of work authorization to minimise gaps. For Australian nationals born in Australia, this, even if the primary spouse is in H1B status, this will not, the H4 spouse likely will not end up getting an H4 EAD, because the way that the green card process is happening now, you'd have to have started the green card but to get that H4 EAD, but most Australian nationals will be able to apply for an EAD through filing the adjustment of status part, because that can be filed at the same time as the I-140 now. And this is getting a little bit complex, but if you're an Indian-born or Chinese-born Australian, then this could be very relevant for someone who is going through the green card process. And later I'm going to touch on, should people switch from an E3 to an H1B, if they're going to go through the green card process. For Indian nationals and Chinese nationals, it is worth switching to an H1B because of how long for those people born in India and China to take to get a green card. And the green card process is based on where you're born, not just your nationality. So that's just important for people to notice. Automatic extension of EADs, I touched on that. That's really more for the H4s right now. Where it comes into play for our E3 and E3D clients is if you did already take advantage of this. So I'll give an example of this, Louisa, to make it easier. If your EAD was expiring December 31st, for example, and you filed the extension of your EAD before that expiry, so December 15th, you filed your EAD extension, you have to have timely filed your EAD extension before it expired and have it still at least 180 days left on your I-94, and your EAD would be automatically extended for 180 days. So that person that files their extension on December 15th for their EAD that was expiring December 31st would automatically have their EAD extended and their work authorization extended until June 30th, right? So where this comes into play with incidental to status work authorization is that that person wouldn't need to leave the US and come back in right now because they have work authorization up until June, let's say. So, but in June, and because EADs, we're going to get to, are sped up, they might even get their EAD before June, in which case they wouldn't need to leave and come back to get that incidental status either. So what we're going to see is sort of like this period of overlap where people are going to still use their EADs, this automatic extension of EAD period for their employers, and then eventually it's just going to phase out because E3Ds and L2s will not need to apply for EADs. So when people that have their current EADs expire, they're not going to need to apply for a new one. So we're going to see those phase out. And then what people will do is this incidental to status where they're just using their I-94, their passport and their visa, as long as their I-94 is correctly annotated for their work authorization. So the good thing about that is it's a lot cheaper for E3Ds and faster. They can start working as soon as they get to the US, which is amazing. It's a really, really big difference. Okay, so that's really what that's about. J2 visa holders, so spouses of J1s, they are authorized to work in the US, but they still have to apply for an EAD. So no incidental to status there for Js. O1 spouses, F2 spouses of F2s, which are the spouses of F1s, and P1 spouses, which are the P2 visa holders, they still do not have work authorization. So where this is important is we have a lot of clients that will say, oh, I'm thinking of switching from H1B or E3 or OPT to an O1. If you are on an E3 and your spouse is a dependent spouse on an E3D and reliant on that work authorization, and this is very much the case for any spouse that's not an Australian themselves, they'll be very reliant on that EAD. So that if the primary person is considering switching to an O1, because sometimes O1s can give more flexibility in what the person can do in the US, if it's going to mess up the work authorization for the spouse, then that would be a reason to potentially stay on the E3 rather than switch to O1. So for anyone thinking, oh, should I switch to an O1? If you have a spouse, think about your spouse. If your spouse is Australian, maybe Australian can get their own E3, in which case then what I would suggest is maybe make your spouse the primary E3, and because if you're switching to an O1 because you want flexibility, maybe you become an E3D and then you'll have full flexibility. The nice thing about for E3D spouses, L2 spouses, all these spouses that get automatic work authorization incidental to status is that they can work in any field doing whatever they want, part-time, full-time, you know, working, having their own business. They can do anything they want with that work authorization. So it's actually the spouse that gets all these benefits, whereas the primary must work for the employer that is sponsoring their E3 and can't do any alternate work for any other employers unless they have a concurrent E3 and then they have 2 E3s and working for 2 employers. But the spouses here are really getting a really good end of the deal. So often when we do a consultation and people are married, we'll look at both to see how can we best position this for the couple. So I encourage couples that are married to look at their situation from both angles now. Okay, what do we got? Oh, we were talking about O's. So I'll whiz through this. I know we did have some questions from someone that asked what's the processing times for O's right now and what is the status for O's right now. So generally O's, there are a few different categories of O's. There's O1As, which are for business. There are O1Bs, which are for arts, which is really confusing because you would think O1As for arts and O1Bs for business, but it's the other way around. Then we have for science and athletics, and then we have an O1 that's for motion picture and television. So the class that's adjudicated at the easiest level is the arts category. And then the other categories, including motion picture and television, are adjudicated at a much higher level. So if you're in motion picture and television, you have to be recognized as outstanding, notable, or leading in your field. So you're compared against others in the field of television, motion picture and television. So recently USCIS said, you know, there are a lot of jobs here that people are classifying as arts, but really it's motion picture and television because mediums have changed, right? We had, before it was either motion picture and television, and we didn't have all these streaming channels of Amazon and Hulu and Netflix. And so I think a lot of attorneys might have been trying to position cases where someone's a producer and say that they're arts so that it'd be easier to get a case approved. And that's just good strategy. But now USCIS and say that, you know, well, Amazon or a TV commercial is not motion picture and television. It's not a TV show. It's not a motion picture because it's not in the cinemas. This is, you know, a HBO, which is really just streaming. So USCIS come back and said, well, anything that would typically be considered similar on these streaming are going to be considered motion picture and television. So one example is they said web materials, self-produced video blogs, social media content will not generally fall into motion picture and television, but streaming movies, web series, TV commercials, which is a big one, and other programs will. So you just want to, if you're an O1 and your art form straddles potentially being on TV and motion picture and considered that way, just really talk to your immigration attorney about how that gets positioned. And lastly, like TV hosts and judges will be considered on reality TV shows, will be considered MPTV, but a contestant won't. So, which is interesting. Yeah.
So in case anyone doesn't know what the O visa is, Zjantelle, is it for outstanding, or is that just in my mind that O stands for outstanding?
So the O's is for aliens of extraordinary ability, is actually what it is, and have to be measured as extraordinary in their field of what they do. And there are certain requirements that have to meet. They have to have won awards, have press about them, have worked for an organization of distinguished reputation, been in events of distinguished reputation, receive a high salary as compared to others in their field, have other critics within their field, you know, write testimonial letters on their behalf saying that they are really at the top of their field. You don't need to meet all of those, but you need to meet at least 3. We like to meet at least 5 when we submit one, but that's definitely what you need to be quite extraordinary. And sometimes people come into our office and they don't think they're extraordinary, but next thing you know, we've made them extraordinary, and they are. You know, we have a lot of.
I feel like because I'm based in Cambridge, the Australians I meet here, so many of them would qualify for this. You know, they've all got tons of publications, they're all leaders in their field. And I always feel like a lot of them are a really great candidate for an O.
Absolutely. We just filed a case actually that's really interesting in this motion picture television field. We have a guy who is a celebrity chef, but he has a book coming out. He has other appearances as a celebrity chef, but he also is on a television show where he catches the food and then cooks it. And so we filed it actually under arts because the TV show's only had one season and hasn't won any awards yet, and is not super well known. So strategically, we filed it as celebrity chef, and that really he's under the arts and not in motion picture and television. But it'll be interesting to see if USCIS comes back to us and says, well, really, this is motion picture and television. We're prepared if that does happen. But we're using this. We're going to see how this comes back. Where we've seen it also is for our we do a lot of visas for O1s for our advertising clients, and our producers and directors. Often USCIS would say, oh, well, they're producing a TV commercial, so we think this is motion picture and television. And in the past, historically, we were able to say, well, no, this is really advertising. It's not motion picture and television, and so therefore it should be adjudicated as under the arts, and they agreed. But I think now we're going to, I think if they're producing television, commercials, I think they're going to pretty much classify it under motion picture and television. So I think we'll be positioning those cases that way now. So it's just an interesting change for people in O1s. Oh, so to answer the person's question, timing-wise for O1s, we are seeing regularly filed cases get approved in about 6 weeks. And then obviously with premium processing, those ones get adjudicated in 15 days. We got one approved today that was filed 7 days ago. So even the premium processing ones are coming back approved much quicker. So far, we've seen approvals. We haven't seen really any issues with O1s. We, touch wood, haven't really received any RFEs either. So if you have a strongly prepared O1, you should be good. And O1s are good right now. Okay, so I wanted to touch on this because I still get questions. In fact, today I had a client with urgent. I have a British passport. My parents in Australia aren't well. They live in Australia. I tried to get a visa during the pandemic and I didn't get it. And I need this visa to be able to get into Australia. And I was like, yeah, hold up. As of February 21, you don't need a visa anymore to get into Australia. If you're not Australian, you can get into Australia with the ETA, which is like the ESTA to the US. You just need to be fully vaccinated. So if you are, and this applies also now for all our Australian clients that during the pandemic were going home and either their spouse did not hold an Australian passport or their children didn't have an Australian passport, they needed to get an exemption for their spouse and children to get into Australia. And anyone that was traveling to Australia otherwise needed to get a visa if they were a foreigner. So now, as of February 21, you don't need to get an exemption for your spouse and children if they don't have an Australian passport. You could just go there as long as they do these things that are on this screen, and others that are non-Australians wanting to go to Australia can enter Australia with the ETA and then these things, which is one, if you're not Australian, you have to be fully vaccinated. The acceptable vaccines are the ones listed there: Pfizer, AstraZeneca, Moderna, Johnson & Johnson. Then you need to complete a digital passenger declaration form, which we've got the link there. But most countries right now, if you've traveled internationally at all, nearly every country you enter has a declaration form that you have to, fill out before you get there. That you say you're vaccinated, you don't have symptoms, yada yada, where you're going to be. Proof of full vaccination. So you need to show your vaccination certificate, and then you need to also show that you have a negative COVID test. It can be, if it's a PCR, it has to, or an AAT, has to be taken within 3 days before your flight. If it's a rapid test, then that has to have been done 24 hours before your flight. So I wanted to point that out to people. Anyone going to Australia, if you get a PCR, it has to be within 3 days before. If it's a rapid test, it can't be within 3 days. It has to be within 24 hours. So if you get a rapid test 2 days before your flight, you show up at the airport, it's not going to work. So just want people to be really, we've had clients in that situation where they're, oh my God, and they're going and getting a rapid test.
And the rapid test can't be just one that you just do and present, right? It has to be supervised. That's right.
Yeah, so it can't be, the one you do at home and you take your stick to the airport. You do need to do the one that's at the pharmacy or at CityMD or one of these places that will email you the negative result so that you can show that paper result either on your phone or print it out. Usually, I tell people to print it out usually. So if I want
to mention, Zjantelle, they do take that 24 hours seriously, because I had a friend whose spouse, the takeoff time was like 2 hours, and they almost did not board.
That's
so
right.
24 hours is a very strict deadline.
Yeah. And it's tough, right? Because you're running, before a flight, you're running around all over the place. So, it's like, should I get the morning off? And then, but what if it doesn't come back on time? So it's quite stressful. So just plan. I normally tell people, try and do it as close within the 24-hour period as you can, but or just get the PCR within that 3-day window. Maybe do both so that you've got a backup. A lot of my clients just do both. Unvaccinated Australian citizen permanent residents can enter Australia, but then they'll have to quarantine. Right now, there's no quarantine in most states, but if you are unvaccinated, there is quarantine, and that changes state by state. The other thing I want to go into is because a client this week said, we're traveling back to Queensland, we haven't been back, and the whole pandemic, my 2 children, one's 9, one's 7, they're not vaccinated. What's the deal? Are they going to be able to come into Queensland with me and my wife? We're vaccinated. Can you look this up for me? So we looked it up, and I thought this is worth bringing up. If you have children that are unvaccinated, all the states have different requirements. So if you're flying into Queensland, if your child's under the age of 16 and unvaccinated, the child will be treated as if it's fully vaccinated, as long as it's traveling with a vaccinated adult. So in this instance, my client's 7-year-old child and 9-year-old child were unvaccinated, traveling with their vaccinated parents, entering into Queensland, will not need to quarantine and will be treated like their vaccinated parents. So New South Wales is the most liberal. If you're you can be unvaccinated up until you're 18 and still enter Australia as long as you're traveling with a vaccinated adult. If you're not traveling with a vaccinated adult and you're unvaccinated, in these instances, then you will be subject to the quarantine requirements. Victoria and the ACT were strange, I thought, because they were 12 years and 2 months. Don't know what the 2 months is for, but if you're over 12 years and 2 months and you've not had 2 doses, then you need to quarantine. And then you've got South Australia, Northern Territory and Tasmania. Similarly, the age is 17. And guess which one's the strictest?
Poor friends, my poor friends in Perth. Brutal.
Yeah, so Western Australia does not have any kind of exception. As long as the traveller is eligible to be vaccinated, then they have to show proof of vaccination. So that's Western Australia. Okay, what do we got for the US? How do you get into the US? The reason I want to bring this up is because the last time we did our webinar, it was that you had to have a negative COVID test taken within 3 days of your flight to the US. That has changed to 24 hours. So similar to that rapid test for Australia, but the US is only 24 hours. So you have to have a negative COVID test taken within 24 hours of your flight. The only alternate document to that is if you have had COVID in the last 90 days and you have a letter from a doctor with a proof of recovery from COVID in the last 90 days. So we have a client actually who, I think, Louisa, you were even mentioning this, that you have someone that needs to travel frequently and he had COVID, and so he wants to get the letter from
trying to get it. He's
just
trying
so
to get COVID right now.
COVID
but we
test
don't have any friends who have it right now.
Yeah. So for people that travel frequently and have had COVID in the last 90 days, that letter could be useful rather than having to get COVID tested every time. But otherwise, getting that negative COVID test within a day of your flight, it's a little bit better than the Australian one because it can be the day before, any time the day before. So you can get it at 8 a.m. the day before and be flying at 6 p.m. the next day, and that will be fine. So it's not 24 hours, it's the day before. So in addition to that, you need to show, if you're not a US citizen or permanent resident, green card holder that is, then you need to show proof of full vaccination to get into the US. And I just want to make it clear that it's not either or. So we had an email from someone earlier this week that said, I have had COVID in the last 90 days and I have a letter from my doctor. So therefore, and I'm not vaccinated. Can I just use that letter to get into the US? So no, you have to show proof of vaccination together with that letter or the negative COVID test. So proof of vaccination is always required if you're not a US citizen or permanent resident. This particular client, she is traveling from the UK and she is unable to get the vaccine for health reasons. So she did get a letter from her doctor that said she had a bad interaction with the first dose of the COVID vaccine. And then she had relatives that had actually died from the vaccine. And this is a very rare situation. So she did have a letter from a doctor that said she could, have very adverse reaction and possibly even die if she gets a second shot to the vaccine. She is actually, I think, on the plane right now. Oh, yes. All right, so I've been waiting for this because she was going to land at 5:40. And so I said to her, please let me know if you get in with that letter. I mean, you can't get much stronger than that letter. And she got on the plane and she just landed in LA and she got through. So if you do have, so that's just evidence right there that if you do have a letter, if you can't get the vaccine, that letter will work. So that's good that that came in time. I was hoping that it would come in time for this webinar. Okay, great. Also, you know, of course, wherever you're traveling to, make sure that you check the vaccination and testing requirements for that destination. We've talked about Australia and the US here, but, you know, if you're traveling to Europe or somewhere, Canada, Mexico, somewhere to get your visa renewed, just make sure you check what they're vaccinated. Look, you have to, if you're going to get a visa renewed, you need to be vaccinated to get back into the US anyway. So don't go traveling to renew your visa if you're not fully vaccinated or have this strong doctor's letter to be able to get around that. Okie dokie. So next up, we were going to talk about, it's H1B registration period right now. It closes on Friday, the registration. So anyone who's considering entering into the H1B lottery, now is the time to file. I've had a lot of Australians contact me with, you know, should I switch to an H1B? So I want to cover this from two angles. One is from people that aren't already here on an E3 or another visa category and are just looking at visa categories to come to the US. As an Australian national, it will be 99.9% that you would just get an E3 for your first visa into the US. And the reason being that the H1B, firstly, there's only a limited window you can enter the lottery, which this year was March 1st to March 18th. Once you enter the lottery, you've got about a 1 in 4 chance of getting selected in the lottery. And then your earliest start date is, if you get selected and approved, is October 1 of that year. So say you had an Australian national that says, I'm going to get an H1B, they need to be in the lottery now, they need to get selected in the lottery, then approved, and then the earliest they'd be able to come and work in the US is October. So it doesn't really make sense when you can get an E3 at any time of the year and be working here as soon as you need to. So most Australians would not opt for an H1B as their first visa into the US. They would pick the E3 over the H1B. But if you're here, the most common scenario we have and questions that we have from Australian clients are, I'm here, and typically what happens is during this period of time, they get an email from the immigration firm representing their company that says, hey, we're doing the H1B lottery registrations right now, and we think you should enter the lottery and the registration. So then I get a call saying, do you think I should? So then I go through, the process I go through with the person is, firstly, well, do you have a spouse that is dependent on your E3 and needs that work authorization? Because if you do, you would not want to switch to an H1B where your spouse then can't work. So that's the first thing I would look at. If they don't, okay, so you have a spouse, yes, they're dependent, okay, don't get an H1B. I have a spouse, no, they can get their own E3, okay, then I'll go through what would be the same as if you don't have a spouse. So I would say, okay, so are you interested in pursuing a green card? More often than not, yes, I am. Okay, great. And sometimes no. If the answer is no, then I would stay on the E3 because you can renew the E3 indefinitely. And we've had clients on the E3 for 15 years or more without issues. Sorry, but the H1B has a limit of 6 years. So if you never want a green card, it doesn't make sense to then switch to an H1B, which has a limit of 6 years, and then the natural progression is a green card. But if you do want a green card, and some people don't want a green card for tax purposes, if you do want a green card though, because you see your life is going to be in the US for a long time and there are no tax reasons why you shouldn't get a green card, then my next question becomes, okay, well, do you need to travel frequently for work or any other reason internationally? Because the advantage of having an H1B to a green card rather than E3 to a green card is that if you're on an H1B, you will be able to travel internationally for the whole period that you are transitioning from H1B to green card. Whereas if you're on an E3 and you are transitioning from E3 to green card, there will be a short period, and actually during the pandemic, it's been a long period because it's been about 8 months, but hopefully we'll see that shortened to maybe 4 or 5 months, where when the adjustment of status part of the case is filed, and that happens right now, that happens at about 14 months into the process. At that point, there'll be a period of about 4 months that you will not be able to travel internationally. And in worst case scenario, 8 months, which is what has been happening during the pandemic. Hopefully it won't be that bad. So if you're on an E3 and you don't need to travel internationally very frequently, and you're all right to be in the US for a period of about 4 or 5 months without traveling, then you can certainly go from an E3 to a green card. And we've done it multiple times very successfully without any issue. You just want to time it right. So you want to renew your E3 and start the green card. The green card takes about 2 years to do. But you can also, at certain spots, once you've started the green card, there will be, up until you file the adjustment of status, you can even renew an E3 without issue. And once you file the adjustment of status, you don't need to renew your E3 anymore anyway. So definitely not everyone needs to switch to an H1B. And often I'll say, look, I don't think, if you don't need to, then for the people that really need an H1B because they've got 0 other options, you're taking a lottery, space away from someone that really needs it. And you may get selected and then decide, oh, I'm not going to use it, but then that number's already taken. So if you do enter the H1B lottery, then you do have a limit of 6 years on the H1B and need to start the green card by the end of your 5th year in H1B status. I listed also the H1B is super expensive. By the time you've filed the case, you have, if you opt to do premium processing, you can have spent up to close to $5,000 just in filing fees. And that's not including lawyers' fees or then going to get the visa put in your passport afterwards. So clearly the E3 is a much cheaper option as well. I've just highlighted again.
So Zjantelle, this probably isn't correct. Like my impression is that there's like 1 million E3s available. That's not the right number. But you've said that the H1B, you've got a 1 in 4 chance of getting it. But how many E3s are available for Australians, and will we reach capacity ever?
That's a really good question. So there are 10,500 of them every year, fresh ones that come out. Counted against the cap are only new E3s. And if you're a change of employer E3, you count it against the cap again. But if you're renewing your E3 with the same employer, you're not counted against the cap. So as many E3s there are here, we have so many and we never reach the cap each year. In fact, this is a good opportunity to bring up as well a concern that has been, I did get a lot of emails about a month ago from Australians saying, oh, is there a threat to the E3 from the Irish trying to obtain our E3? This is not currently a threat. It did come up a couple of years ago, but it's dormant. But the Irish did say, well, look, you guys don't use it all up, so maybe we should at least take your leftovers. And if that ever did happen, they would only get the leftovers each year that we didn't use. But right now, that's not even on the cards. So the E3 is here. It's safe. It's here to stay. Clients have asked me, should I even be renewing my E3? Is it going to be around? I'm like, absolutely, you should be renewing your E3. We want to be using it so that we get to keep it as well. But it's not under threat. So I just want to assure people of that. And I have a very close relationship with the congressional liaison, people at the Australian Embassy in DC that have direct insight into this. And when it was happening 2 years ago, they invited me to work on it with them and make improvements to the bill on the E3. So I'm very closely attached to that situation. So I can very much assure people that we're safe. The E3 is good. I did want to bring up my last comment here is just for E3s that should be thinking about switching to a green card and who might think about it is I often talk about it with my clients that have kids because as I mentioned before, E3D children or and L2 children, anyone who's on a non-immigrant status, their children can't work. And we have a lot of clients now whose kids are 15, 16, 17, and they say, okay, well, my kid wants a part-time job and on a dependent visa, they can't. But if they have a green card, they can. So, and then the other thing is that children age out of being able to be a dependent on the parent's visa at age 21. So we see kids that go off to college and then partway through college, if they haven't finished by the age of 21 to then get their own visa, they need to switch from their parents' dependent visa that they've been on to an F1. So often I'll say to clients with kids, once your kids hit about age 15 is when we should start thinking about, would it be appropriate for us to apply for a green card for our kids' sake, more than just the parents' sake? So if they think, oh, look, we're probably going to be in the US a long time, my kids are going to want to work, my kids are going to want to stay here and be in college here, then it's a really, that's around the time you want to talk to your immigration attorney about starting the green card process. And I have a set of clients that came to me after the fact, and then we started the green card process, but unfortunately they didn't have that conversation. So they have 3 kids, and the oldest kid aged out. We had to get an F1 for the oldest kid, and now the 2 youngest kids and the parents have green cards. But the oldest kid will have to find his own path, and after he finishes at college, he's going to have to get an E3, then he's going to have to get his employer to sponsor him, because to sponsor a child over the age of 21 as a parent takes a long time, takes about 10 years. But if they're under the age of 21, they get the green card with you immediately. And siblings too can't sponsor their siblings. It takes about 12 years, so it's a long time. So it's a big dramatic difference if you don't get your kid a green card before they turn 21 to their journey towards a green card. So that's why I encourage anyone with kids, talk about it by the time the kid's 15. You watch, my inbox is going to be flooded now with everyone who's got kids that are 15 years old tomorrow. Okay, next up.
I want to check in with you, Zjantelle, a quick time check for you and our audience that we've got about 15 minutes left, but we may run 5 minutes over, and I want to assure everyone it is worth hanging around because there's some great content right at the end.
Okay, great. I'm going to try and zoom through this. This is alcohol-related offences. So if you have a DUI, public intoxication, any open container, any arrest related to alcohol can do 2 things. Number one, and we got a question about this, Louisa. You had someone emailed saying, my visa got revoked because of an arrest, and now what do I do? So if you have an alcohol-related arrest in the US, your visa can get revoked, meaning that they'll cancel it out. Sometimes they'll notify you. The way you rectify that is that you have to leave, get a new visa, and come back. When you leave and get the new visa, you have to go see a physician, and I'm going to talk about that. But sometimes you're not notified, and you travel abroad, and you try and get on the plane to come back, and they say, no, this visa's been cancelled out. And you're like, what? If you've had an arrest related to alcohol, that's why. So I'm sure that person that said, they didn't say what the arrest was for, but I think it was probably an alcohol-related arrest. They asked, can they come back in on ESTA? So the questions on ESTA are different to the questions on a visa. Questions on ESTA say conviction rather than arrest. So should be able to come back on ESTA, but you have to apply for a new one, then come in, or apply for a visa. And so what happens when you apply for a visa and you've had an alcohol-related arrest that's in the US or outside the US, because we had a client last week who was like, but it happened in Canada. Doesn't matter where it happened, you do have to disclose it, because the question is arrest or conviction. So even if you're arrested and then it was dismissed and so forth, you still have to disclose it. If you've had one single alcohol-related offence in the last 5 years, you will be required to go to a panel physician. If it remains that way, the next visa that you do, because it's like 2-year increments, you won't have to go again. But if you have 2 or more alcohol-related offences in the last 10 years, every time until 10 years goes by that you renew your visa, you will have to go see a panel physician. What that means is you'll go to your visa interview and they'll say, okay, we need you to go see a doctor. They give you the name of the doctor that they want you to go see. You have to go do a walk a line, do these, things, and they test your breath, and, they want to test that you're not a habitual drunkard. Actually all of our clients have passed that test, so that's good. But it will delay the visa processing. So when you think you're going there, you're going to be done in a week, you're stuck there for 2 weeks. We had one client who renewed his visa in Colombia recently, and he had an alcohol-related offence, and because of the language barrier and so forth, and the doctors being closed, and it was holidays and this and that, he was there for 3 weeks by the time the physician got the results to the consulate and the passport issued. So just know, if you have an alcohol-related offence, it can delay your visa processing. So just don't drink and drive. That's what I say. And just don't drink. But you will have to drink, but just drink at home and don't go out and be silly and get arrested for it. Okay. Pardon me. All right, E3 visa processing times. I'm going to try and speed through these. I know. So securing a visa in Australia. There's no appointments in Australia right now. The Sydney consulate's closed. Perth opened up to travellers, and so all the appointments in Perth got taken up. Melbourne consulate is open and accepting appointments, but they're backlogged to September, October. And Melbourne is the only consulate also facilitating the mail-in. So it's so backlogged that if you do decide, if you're in Australia right now and you don't have an E3 yet, you do, and you've never had an E3, first-time E3s do not qualify for a mail-in. And so therefore, most of those people, I'm telling them, get an appointment outside of Australia, because otherwise you're going to be waiting till September, October. And you can get appointments outside of Australia right now, almost anywhere. So on the way, if you want to get an appointment on the way to the US, you could try Thailand, Singapore, Dubai, stop there on the way and come in. We've also been able to get people appointments in Canada, Mexico, Europe. There are so many more appointments now than ever before. So it's not as big an issue as it once was. If you have any trouble, we can definitely help. For those people that are wondering about Barbados and Bahamas, which were the fan favorites for so long, those two consulates still, you can't get appointments at. You'll hear of people still doing Bahamas appointments. Those are appointments that they booked ages ago. So we had a client recently that went and renewed in Bahamas, but we booked that for her last June. And those were not getting cancelled. But we're seeing Sydney, people were able to book appointments in Sydney. So if you've got an appointment in Sydney in April, we've just seen those get cancelled. So that'll probably get cancelled. So you'll want to re-strategize, try and get an appointment outside of Australia if you need an appointment. If you've had an E3 before, or you're a first-time OPQ, so forth, the ones that are listed there, you can qualify for the mail-in. So which means you mail in your documents, you don't have to go to an interview, they put the visa in your passport and they mail it back to you. That currently, it was in the pandemic, before the Christmas holidays and before the Sydney consulate closed, we were seeing people getting their passports back in less than a week. Over the Christmas holidays, we saw it blow out to like 5 weeks. Currently, we're seeing the mail-in take about 2 weeks and sometimes 3. So if you're going back to Australia to renew your visa, I really only recommend that if the people that do that, our clients that do that, are people that haven't been back through our pandemic and they're like, I haven't been there in 2 years, I'm going to go for a month anyway, so I'll do the mail-in, I've got plenty of time. If it takes 3 weeks, that's fine. But if you want to do this quickly, I don't recommend going to Australia to renew your visa. Right now, I would sooner find a consulate close by, and there are lots of consulate appointments close by.
And the mail-in is only if you're in Australia. You can't do the mail-in if you're outside of Australia.
Correct.
Right.
So you need to be in the consular district of the mail-in, and you need to be an Australian. Well, you need to be an Australian for an E3 anyway. But if you're an O1 and you're not Australian and you don't reside in Australia, you couldn't do the mail-in there. So other countries have the mail-in too. So let's just say Germany has the mail-in, UK has the mail-in. But as an Australian, you can't go there to one of those countries and do the mail-in. You can only do an appointment in those countries. You have to be a British national to do it in the UK, or a German national to do it in Germany, for example. We tried this. We had a client who was a Kiwi and Brit. So he had both passports. He had an O1, and his previous O1 was in his New Zealand passport, but he had his British passport. And so we saw, okay, if you're a British national, you can do the mail-in in London. So we sent him to London, did the mail-in, and London came back and said, look, your visa was in your New Zealand passport before, so we need you to come in for an appointment. Luckily, they scheduled him for the next day to come in. He got his visa then put into his passport, his British passport, and that was no problem. His Kiwi passport had expired. That's why he couldn't put it back in there, but he wouldn't have even been able to do the mail-in in his Kiwi passport in the UK. So that's why we were doing it in the UK passport. But yes, now the UK has said you can do first-time O1s. When he did that, it was a couple of months ago. Before, they said you could do first-time O1s to mail-in. So I think if he went there now, it would be different, because they would treat it like a first-time O1 in his British passport, and in which case probably would work now. So if you have multiple passports as an Australian citizen, if you're getting an O1, an E3 has to go into your Australian passport. But if you're getting a different visa category, and like an L can be put in your Australian or your other one. So this opens up more options for you as well. Okay, so the benefits of having more than one passport. And also, of course, we've got the I-129, which is the in-country filing. We have the benefit now of premium processing for that. So those are taking 15 days. what the other time we were seeing before in our last webinar, we were seeing E3s that were filed regular filing taking about 9 months to get approved. They're now taking about 2.5 to 4.5 months. So you would really only use regular processing for an E3, I-129 E3, not for a change of employer, because that's a long time, but you would use it for an extension of your E3 potentially, because E3s now, when they get filed as an extension, get an automatic 240 days that they can continue working once the extension's been filed, and then that's getting approved. That's more than 2.5 to 4.5 months. So then their case is getting approved in that time that they can keep working, and they can just keep working. So anyone that's filing an extension of their E3 or status in the US could file it within the US. But just as a reminder, next time they travel internationally, they do need to get the visa stamp from their passport. And you can't just take the approval notice to get the visa stamp from your passport. You do need to take all of the usual application documents for an E3, the LCA, the supporting documentation, the support letter from the employer, and all of that when you consular process, even if you just got the approval notice. So unlike an L-H-1B and all of that, where you can take just the approval notice and get the visa put in your passport, E category of visa does not qualify for that. So just want to remind people of that, because I have a lot of people emailing me with, I just got my approval notice, but now I have to get the visa stamp. So when you go get the visa stamp, it's like doing a whole new application again anyway. Okay, so then we're up to our last 2 slides. This was just green card processing times, family-based. We're seeing them that they were taking up to 18 months during the pandemic. We are seeing them go so fast. We have this one that was in Massachusetts that got approved. We filed it December. They had their interview and got approved in March. So that was like 4 months. It was so quickly, January, February, March, actually 3 months. And it went so fast that they didn't even get their EAD in time. So they got the green card before they even got their EAD. We have here in LA, so generally in LA and New York, it's taking about 8 months to get a green card interview, so which is much faster as well. So I've put up here what we're seeing as opposed to what the USCIS website says. So we're seeing it go actually faster than what USCIS is saying, right? Also, what we've seen is EAD cards now are coming really quickly, especially in New York, for marriage-based green card cases. We filed one January 25th, and they already got their EAD on March 4th. So the reason this is coming faster now is that they've separated the documents. When you filed a marriage case previously, the travel document and the work authorization document would come in the one plastic card. They've separated that now in an effort to speed up the work authorization documents. So we are still seeing an issue with the travel document for the green card process, but EADs are coming much faster. Employment-based. So if you're a perm EB2 and EB3, which is perm-based, and those people will know who they are, process takes about 2 years to get the green card. If you're an EB1, the cases that are taking the longest are EB1 multinational managers and executives, so people that are on L going to a green card. Those are still taking almost a year, over a year to get approved. EB1 extraordinary ability cases, we had one in LA that went so fast within 4 months. Before that was taking 14 months, but we've seen that, we saw that got approved in 4 months. We have another one in New York that got approved really quickly. The 485 is still pending, and we're right around 4 months right now. So we're hoping to get an approval and a green card in the mail for them too. What we're seeing as well with green cards right now, predominantly employment-based green cards, under the Trump administration, it was required that when you filed a green card under employment-based category, you had to sit in a green card interview. We're seeing green card interviews be waived and green card cases getting approved and people getting their green card. We're even seeing it under marriage-based cases. So now when we file a marriage-based case, we really add a lot of documentation to show the bona fides of the marriage in the hopes that maybe the couple will get a waiver of their interview and just get the green card in the mail. So green cards have really sped up significantly, which is awesome news. If you do your green card via consular processing, which is picking it up abroad, or you start the process with your spouses abroad, those are still severely backlogged, and that's taking over a year to get your spouse here. So I really encourage people to come into the US and do it from within the US through adjustment of status, because it's so much faster that way. even for employment-based ones as well. I think that might be, citizenship cases, timing, quick. So we're seeing those have sped up significantly too. So in New York, most recently, we filed one in November. And I told this woman, I met her, I was in a gym class with her called The Class, and we were walking out and I said, oh, that's a fabulous coat you got on. And she had an accent and we started talking, and then she said, oh, you're an immigration lawyer. I've been wanting to do my citizenship forever. I said, just let us do it. You'll have it within a year. And next thing you know, she already has it. She went to her oath ceremony just last week. And, you know, here I am telling her 12 months, and within 4 months, she's a citizen. She's like thrilled. She thinks we're the best thing, but it's not really me. It's like, it's just the citizenship is going, making the citizenship applications really fast. So here as well, you'll see California. This one was a long time, but they've sped up so much faster now. And here we've got, well, let's go to this one. This one was still during the pandemic, but it still took 5 months in Boston. Then got and then this one here, you might recognize.
All right, I'm outing myself. That's my application for citizenship.
And I told you too, I was like, oh, about maybe 8 months, 6 to 8 months. And here we are 5 months in, and you've got your interview. So
I applied in October. It said when I applied that it would take 13 months. Today when I logged in, it said it would still take 12 months, but I have this interview. And so for the audience, if anyone's going through this process, because it comes around so quickly, my advice is start studying for the civics test now, because it just came around so quickly. I thought I had 13 months to study for this test, and now I've got 2 weeks to study for this test. And the test is the 100 questions about the Constitution. And so I advise you, to take notice of these speedy times.
Louisa, you're going to be fine. It's like studying for a driving test. You just cram it all at once. Get your son to do flashcards for you and ask you the questions. So they'll ask you 10 questions. You only have to get 6 right. If you get 6 right, they only ask you 6 questions. If you get the first 6 right, they'll only ask you the first 6 questions. And then you speak English pretty well. You have to read a sentence.
Everybody wish me
luck.
Write
a sentence in English, like the cat sat on the chair. I think you'll be all right at that. So I think you're going to pass with flying colours. You're going to be great.
I'll let you all know on the next update.
And then I think you'll probably get your oath ceremony within a month. So by the end of April, you're going to be a US citizen.
And I also share with the audience that one of the things that motivated this was the end of the pandemic, when it became so difficult to travel back and forth with a non-Australian or non-US, like a different combination in the family, someone having this passport, having that, and it just made sense for us all to match and all to have the same passport. So if anyone else is in this situation, then so far I recommend the process.
Yeah, good job. And I think that comes to our last slide, the disclaimer. This is not legal advice to anyone in particular. Everyone's situation is unique, so you should definitely seek advice for your personal situation from an immigration attorney. And then our contact details. And I think there were a few quick questions.
There was a question from Anne. I wanted to ask Anne's question, which was, can you return to the US with an expired passport?
That's an interesting one. So technically, if you arrive in the US with an expired US passport, they will let you in. The tough part is getting on the plane. So if you have any other passport that is expired, you will definitely not be able to come into the US. But for the US passport, America will let in its US citizens, even if their passport is expired. So like I said, the problem is going to be getting on the plane, because what's going to happen is you're going to go to the airport, they're going to see an expired passport. They're not going to want to let you on the plane. They're going to try and contact Customs Border Patrol. They might not be able to get through to Customs Border Patrol. So if you had 2 passports, you could use potentially your other passport to get on the plane and then enter with your US passport. So you make sure you're entering as a US citizen. I actually tried this as a guinea pig with my kids, Louisa, over the pandemic. My kids' US passport had expired, and we went to Mexico, and they entered Mexico with they have 3 passports. They're very lucky. So I entered with one of their other passports, and then to Mexico, and then to come back to the US, I knew they had to come in on their American passport. But I already knew I'd be able to get them in, because I'd spoken to Customs and Border Patrol and so forth, and they have to let them in if they're a US citizen. But it was a song and a dance at the airport. Like it took an hour for, they were like, oh, CBP doesn't really want to let you in with these. I knew that we would get in, so I wasn't too stressed, but anyone that wouldn't know that would be freaking out. And then, you know, after an hour, it's like, all right, well, your lucky day. We're going to let you on the plane today. But yeah, I don't recommend it. So for the person that did email that I think is in Australia and said they couldn't renew their passport because they're in Sydney and the Sydney consulate's closed, I would contact, there is a special line when you contact US consulates, there is a special, and you can get emergency passports in the US now too. So if anyone needs advice on that and they're in the US and need to get a US passport, we can sort of guide a little bit on that. But if you're abroad and trying to get, and you're in Australia, like this person that emailed, if you call the US consulate, there is, you know, it will say if you're an American citizen, press, you know, I don't know which number it is, but it's a number, 1, 2, 3. Anyway, press that number and then you will actually be able to get through to someone. And then they will prioritize American citizens and services for American citizens over Australian nationals or third country nationals, other nationals. So hopefully that person can get their US passport renewed because it'll just be much easier.
And promise, this is the last question. If you've got an expired green card and you want to come back to the US, which I know probably some people are affected by.
So definitely, as long as your green card was a 10-year green card, I'm going to stop sharing now. If your green card was a 10-year green card and it's expired, you are able to come back in on that. If it was a 2-year conditional green card, so say you got married or you were in the EB-5 program and your green card expired, you can only come in with that expired green card if you have the receipt notice of a 751 filing. I'm going to share, actually, let me see if I can share, the regional carrier liaison group, and this will also help. We did talk about this in a previous webinar, but I'll touch on it for those people that did, you know, back in Australia and saying, like, how do I come back in? I've been out for more, now 2 years, 1.5 years, however long it's been. This still is in play. Regional carrier liaison group, here we go, let me share this. So this is the policy that the regional carrier liaison group, carrier liaison is CBP in the US. And that's who, when you go to the airport and an airline official doesn't know whether to board you or not, they contact regional carrier liaison group, which is a section of Customs and Border Patrol that will look into the person's situation and say, yes, board them, or no, don't board them. So because of this whole situation where people were stuck abroad for a long time, couldn't come in, regional carrier liaison group gave this notice to, which the airlines should have. Clients that are traveling in who haven't been here for a long time but are permanent residents, I often give them this notice that they can take with them to the airport. But if you have it, this is what they've been instructed to do. An unexpired green card, no matter how long you've been out, you should be able to get on the plane. So as long as you've got an unexpired green card, you can get on the plane. If you have a re-entry permit, they should board you on the plane. If you have an expired green card that was a 10-year one, you can get on the plane. If you have if you have an expired green card and it was one that was not a 10-year one, then you need to have a receipt notice of your filing for the extension. We can help people with that. Expired conditional resident, that's again another one of the expired conditional resident cards. SB1 visas, I don't recommend people, you can't even get one of these in Australia right now, you can't even get an appointment at the consulate. So I don't recommend people trying to do this. I say if you have a green card, regardless of whether it's expired or not, just try to go to the airport and try and board the flight. The hardest part is boarding the flight. Once you get on that flight, and if you have an easy time boarding flight, great. If you once you get in the US, they will let you in. I've not had one client that has had any trouble getting in. There was a question from someone that said, and they must have listened to our previous one where I said, you know, look, if you do have any trouble and they try and say to you, sign an I-407 to give up your green card because you've been out of the US. I said, do not ever sign that as long as you don't want to give up your green card because you're not required to. And you just say, well, I'll rather fight this out in front of an immigration judge. And the person's question was, if I end up in front of an immigration judge, will I be able to work and travel in and out of the US? Yes. So what will happen is they give you a notice to appear, and that the process is so delayed that you can come and go, you can work, you've still got all the rights of the green card holder. If that ever did happen, and so far that's not happened to any of my clients, but if it did, I would say to my clients, like, you know, if that happens, and you're scheduled to appear in front of an immigration judge, you would want to try to spend more time in the US than out of the US, even though you can travel in and out, just so that then by the time you go in front of the immigration judge, you can say, look, I mean, I do want to keep my green card. If you look, I've been here more than outside the US in the last 6 months before this interview, you know. So that was just to answer that question, because I remembered that one and you brought this up. So hopefully.
And if anyone wants a copy of this, if anyone's traveling there and you're in this situation, just email Zjantelle or I, and we'll share the document with you so that you can travel carrying it.
Yeah, absolutely. I don't know if there were any other last straggling questions that we wanted to cover, or.
I think that's it for today, but I look forward to our next update. Thank you so much, Zjantelle. That was so informative. It was great.
You're welcome. Sorry for anyone if I was talking too fast, trying to get a lot of content in there.
We'll do subtitles next time. All right. But anyway, the replay will be available in the next couple of days. Just check our website if there's anything that you missed or you want to watch again. This was recorded, so it will be available. And Zjantelle, can you make the slides available too?
Absolutely, yeah.
Okay, great. All right. We will share those in an email with you all. Thank you so much for joining. Thanks, Zjantelle.